So friends, karma hangs heavy in the air. Why do I say that? Well, given two deadlines that Judge Tanya Chutkan just set in Donald Trump's federal election interference case in Washington, D.C., it now looks like we may see the evidence of Donald Trump's January 6 crimes as early as October 2nd. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, hold on tight. This is going to be a fully unscripted Justice Matters video because I just read something that Judge Tanya Chutkan dropped on the public record. It's called a minute order and it's 2 sentences long, but it is potentially a game changer. So here's what I want to do. I want to start with the public reporting, just a couple of paragraphs from the Washington Post. Then I want to have a look at a little bit of the new motion Jack Smith just filed, indicating to Judge Chutkan, here it is. Here is the big old mega brief, the oversized motion with all of the evidence of Donald Trump's January 6 crimes. He filed that. And then I want to take on that 2-sentence minute order because now we know, I think for the first time, when we might see the evidence of Donald Trump's democracy-busting January 6 crimes. I'm going to take all of this on. I'm going to translate it from legalese to English. And friends, I never ask you all to watch an entire Justice Matters video. I appreciate when people come to my channel and they click and they watch my videos. But let's face it, we don't always stay to the end of a video if it happens to be 8 or 10 or 12 minutes. I'm going to invite you to stay to the end of this one because I want to lay all of this out because it is so important, particularly coming just weeks before the election. And let me tackle this up front. I've heard people call this an October surprise. I won't refer to this as an October surprise. Why? Well, if you're familiar with politics, you know that October surprise is typically when one candidate or the party of one candidate or the PAC that is devoted to trying to get that one candidate to win the election discloses something about the other candidate that is shocking, earth-shattering, and they hope it has a real impact on the election. It knocks that candidate down when they release this information in October, the big October surprise. That has political connotations. This ain't an October surprise in the political sense. Yes, we are about to be surprised, perhaps, by the evidence of Donald Trump's January 6 crimes. Not really surprised, but we're finally going to get to see the evidence. And yes, that revelation is probably going to come in October, as we'll talk about in a minute. But it's not a political October surprise. This is the court system operating the way the court system is supposed to operate. Judge Chutkan has said many times, I've been in court every time she said it, that her case and her schedule in her case will not yield or be dependent upon any election cycle, and she means it. So I'm not going to call this an October surprise. But let's start with the new reporting and then let's get through Jack Smith's motion, just a little bit of it, and those 2 sentences. This from the Washington Post. Jack Smith lays out January 6 case against Trump. Will filing be public? And friends, that is the $64,000 question, and I think we now have an answer to that question. But let's first get through just a couple of paragraphs of the Washington Post reporting. A nearly 200-page special counsel filing of facts and legal argument on why Donald Trump can be criminally prosecuted for his efforts to overturn the results of the 2020 election landed Thursday in D.C. federal court, triggering a process that could end in the public seeing significant new details of the case before the November election. The massive brief on special counsel Jack Smith's case against the former president, which could run up to 180 pages plus more in exhibits, was filed under seal per the court's order, a spokesman for Smith's office said. It will remain that way until U.S. District Judge Tanya Chutkan decides what she wants to do with the redacted version, which prosecutors also plan to file under seal with the expectation that it will later be released publicly. And now, friends, let's turn to special counsel Jack Smith's filing from earlier today that accompanied that 180-page plus mega brief. In the case of United States of America versus Donald Trump, defendant, government's motion for leave to file unredacted motion under seal and to file redacted motion on public docket. Consistent with the court's scheduling order, the government, meaning the prosecutor, is filing today a motion for immunity determinations motion. Through the motion, the government asks the court to determine that the defendant's conduct in the course of the charged crime is not subject to immunity. The motion is supported by a variety of proof, some of which the government has designated sensitive under the protective order, such as grand jury testimony, materials obtained through sealed search warrants, transcripts and reports of witness interviews, and materials obtained from other governmental entities. The protective order requires the government to submit these materials under seal. The protective order also requires the government to simultaneously submit under seal a redacted copy of the motion proposed to be filed on the public docket. And in the motion, Jack Smith goes on to say basically, Judge, we've done that. We've complied with your orders and directives, and we have filed what you told us to file. Now, before I go on to Judge Chutkan's 2-sentence minute order that tells us when we are likely to see this evidence of Donald Trump's J6 crimes, let me explain where we are. Let me explain what this Jack Smith filing looks like. First of all, there's the motion. 180 pages. What is that? That's going to read like a book, like a novel. That lays out all of Donald Trump's crimes and the evidence supporting Donald Trump's crimes. Now, that's what we would call a proffer of evidence. This is Jack Smith setting out, probably in chronological form, and I'm telling you it's going to read like a crime thriller, even though we know who done it. Donald Trump done it. I digress. I told you this was unscripted, friends. It's going to relate the story of Donald Trump's January 6 crimes and why they don't deserve immunity, why they were not the official conduct of a president of the United States. Duh. And then there is what's referred to as the appendix, right? So the motion is like the book, like the novel. And the appendix, all of the attachments, that's the evidence that supports the proffer, the information that is in the motion itself, the story. There's the story, and then there's all of the evidence supporting the story. That's how Jack Smith's going to prove it. And you're going to see grand jury transcripts and FBI 302's write-up of witness interviews. You're going to see documents, maybe phone records, text messages. That's the evidence that supports what's in Jack Smith's motion. And it's important to keep those two things in mind because Judge Chutkan has said there is one date she's setting for the possible release of the motion, where the story is, and another date that she's setting for the possible release of the appendix, all of the evidence that's attached to the motion that accompanies the motion. The story is what we need to see, because what's in the story, we know it's going to be backed up by the evidence that Jack Smith puts in the appendix. So what Jack Smith was told to do by the judge is file one version of the motion and the appendix that's unredacted, no black bars, nothing blacked out, so she, the judge, can see all of it. And then she asked for a second version, a redacted version, where some things will be blacked out, behind those black bars to protect the secrecy of grand jury proceedings or ongoing investigations, because there are more federal indictments coming for what Donald Trump's co-conspirators did on January 6th. On that, I am sure. But there are some things that aren't quite ready to be released into the public record. So Jack Smith gave her an unredacted copy of the motion and the appendix and a proposed redacted copy to keep all of those things hidden from public view until the time is right. And now it's up to Judge Chutkan what to do with them, when to release them. And now we go to the all-important 2-sentence minute order. Here is what Judge Chutkan said she will do with respect to those documents that were just filed by Jack Smith. Minute order as to Donald Trump. The clerk of the court is directed to file on the public docket the government's motion for leave to file unredacted motion under seal and to file redacted motion on public docket. That's a mouthful, friends, but that's just that short motion that I just read a portion of to you. That's a 9-page filing, and it basically just says, Judge, we're filing everything you told us to file, an unredacted version, a redacted version. Here it all is, and he makes some legal arguments about why some of it should remain redacted. But that is first what Judge Chutkan references in her minute order. Clerk of the court, go ahead and file that 9-page motion that Jack Smith just filed on the public docket so everybody can see it. But then the second sentence is really the most important. It is hereby ordered that defendant, Trump, shall file under seal any objections to the proposed redactions in the government's motion for immunity determinations by 12 p.m. on October 1st, 2024, and shall file under seal any objections to the proposed redactions in the appendix to that motion by 5 p.m. on October 10th, 2024, signed Judge Tanya S. Chutkan on 9/27/2024. Friends, what can we extrapolate? What can we glean from the fact that Judge Chutkan set 2 deadlines for Trump and his lawyers to file any objections to any of this? The motion and the proposed redactions, and the appendix, the supporting evidence, and the proposed redactions. Here's my take. And I've kicked this around with some of my fellow legal experts who are far smarter and more accomplished than me, and I think we are largely in agreement. Here's what I believe Judge Chutkan intends to do. She's going to let Donald Trump and his lawyers file their objections to the motion, the 180-page motion, the narrative, the book, the story of Donald Trump's January 6th democracy-busting crimes by October 1st. And then she'll rule, and she will say, either I accept some of their objections and I kind of will alter some of the proposed redactions by the prosecutors, or I reject their objections. But one way or another, I'm ruling, and then I will enter on the public docket the 180-page motion for all to read. That's the way litigation is supposed to play out. This is all supposed to be done in the full view of the public. That's the only way the people can have confidence in the criminal justice system. If it was all done under seal and behind closed doors, nobody could have confidence in the ultimate result of any litigation. So I have a feeling very soon after Donald Trump's lawyers file their objections on October 1st, we are going to see, maybe as early as October 1st or October 2nd, the story, the motion, the evidence of Donald Trump's January 6th crimes. Then, the second filing deadline that she set for Trump and his lawyers, a little curious. She said, okay, and the appendix, all of the grand jury transcripts and the FBI 302s documenting witness investigations and transcribed witness interviews and documents and phone records and all of the other evidence that is included in the appendix to the 180-page motion. I'm going to give you until October 10th to file your objection to the redactions that Jack Smith proposed in that batch of information, the appendix. and then I'll rule. Maybe I'll agree with some of your objections to some of this stuff being sealed or not sealed, but I'll rule, and then I will make public that batch of information, the appendix, perhaps as early as, October 11th. That's the way I read Judge Chutkan's minute order and her 2 deadlines that she has set. Doesn't mean my take is right, but that is my sense. After practicing in that jurisdiction for decades, in that very courthouse, Federal District Court in Washington, D.C., and knowing Judge Tanya Chutkan the way I do, I used to try murder cases against Judge Tanya Chutkan when she was a public defender doing the extraordinarily difficult and important work of representing indigent defendants in Washington, D.C. in murder cases. I was the prosecutor, she was the defense attorney. We used to go at it. We used to butt heads, and I have such enormous respect for the lawyer and the person she is. I mean, she defended her clients without fear or favor, aggressively but honorably and ethically and civilly, and I had a good relationship with her back then, and I have followed her career on the bench since, and I have the utmost faith in Judge Tanya Chutkan to do the right thing in this case and all cases she handles. So I think that is what we can expect. As early as perhaps October 1st in the afternoon or 2nd, we're going to see, I believe, Jack Smith's motion, and we're going to read for ourselves the story and the evidence of Donald Trump's democracy-busting January 6th crimes. And friends, let me finish up with this. People will want to know, can Donald Trump appeal it? Can he put a stop to it? Can he have some higher court intervene and shut down Judge Chutkan from litigating her case without regard to the election cycle? The answer is he can file whatever he wants to file, but this is not an appealable issue. Judges set scheduling deadlines and briefing dates in their cases thousands of times every day in jurisdictions all across our country. They're not appealable. If they were, we would never get any case to trial because people would forever be appealing and putting a stop to trials moving forward in a timely manner. This is not appealable. Will Donald Trump try to file a bogus appeal? Of course he will. It's what he does. Delay is his game. But those appeals should fall on deaf ears in any appellate court, up to and including the Supreme Court. I know. The radical right-wing bloc of 6 Supreme Court justices have ignored the law and the text of the Constitution over and over and over again to Donald Trump's advantage. Maybe they'll do it again. I'm going to go out on a limb and say I don't think so. You can't appeal scheduling decisions by a judge. I don't think there is much that can legitimately stop this train from running and to stop the American people from seeing the story and the evidence of Donald Trump's January 6th crimes in the first week or 2 of October. But, tomorrow's another day, and Donald Trump and his lawyers will have another trick up their sleeve, I suspect. Here's another thing. People will yell and scream in Donald Trump's camp, and including his flunkies and his sycophants and his lapdogs. This is election interference. No, it's not. This is exactly what Donald Trump asked for. He ran to the Supreme Court, said, yeah, I may have committed lots of January 6 crimes, but I want immunity, even though the Constitution provides the opposite. There's no language in the Constitution, in the text of the Constitution, that provides a president is immune from being prosecuted for crimes he commits against the American people, including to steal an election. But the Supreme Court gave him some immunity. That's what he asked for. That's what he wanted. And the Supreme Court said, fine, you want some immunity? Then what we need to do is give the case back to the trial court judge, Judge Chutkan. She needs to see all of the evidence so she can litigate which of your crimes are the official acts of a president of the United States and which aren't. Which of your crimes should you get some immunity for, and which, should you not get some immunity for? So that's exactly what the Supreme Court told Judge Chutkan to do. Of course, what did Trump's lawyers do as soon as the case went back to Judge Chutkan? You should immediately dismiss it. I think dismiss it promptly is what they told Judge Chutkan. In other words, ignore what the Supreme Court told you to do. Unbelievable. This is what Donald Trump asked for, precisely what he asked for, and he got it. The fact that he got it in October, tough luck, sport, you got it. And what I would say to Donald Trump is buckle up, Buttercup, because your ride's about to get a whole lot bumpier. You know why? Because justice matters. Told you that was unscripted, friends, except that last part. As always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.